YouTube, it's Tone. I'm back with another one for you. This one is a continuation of dealing with presentments. This is number 9. This is the 9th video here. So in the last video, I believe we were talking about how to serve these people. Telling you which agencies to use. So either using the sheriff's department, or you could have them serve with the U.S. Marshals. I think it's like $1.50 a document for each person. So then, you can go ahead and, at that point, you can't pretend that you didn't receive shit when the U.S. Marshals comes and serves you. You know what I'm saying? And that's who you gotta work with when you're dealing with these people that are in higher levels of government. Just to get the point across and to make sure that things get done properly, because everybody's got somebody to answer to. I promise you that. These motherfuckers are not above the law, bro, at all. So, right here, serving subpoena. So, hereinafter, SDT, whether or not you depose anyone for direct questions is appropriate in both state and federal cases. Obtain several officials stamp subpoenas from the court in advance. In the section asking for a document subpoena print, see attached schedule of documents subpoenaed, set 1. And so you want to mark all your documents as if you're going to be presenting them as in exhibit. So maybe A1, A2, A3 for a specific set of documents, and then you can change that up as you go. Because you want to keep good records and be able to make it clear when you're making your presentments and exhibits, so nobody gets lost there. Because they're all going to pretend not to know what the fuck you're talking about, so you're going to have to go into detail on everything. Especially if you have a jury there and shit like that. So, what do you got here? So, see schedule of documents subpoena, set 1. You can have the SDTs served by a process server, the sheriff or the U.S. Marshals, and serve the prosecuting attorneys and perhaps also the mayor of the municipality, because he would be essentially the manager of that corporation, would be the mayor, right? So you want to go ahead and make sure that he's going to be liable for the dumb shit that his little minions do as well, because who is supposed to be liable? You're the one letting them work there, right? So you can pay for that shit too. So which the court is located, and head of the department or accounting department. So it says prosecuting attorneys, perhaps the mayor of the municipality in which the court is located, and the head of the department of accounting of the accounting department, because all of this is commercial. If the municipality department of risk management, so you can go ahead and notify them too as well, because you're going to be placing a claim on their bond if these people don't do the right thing at any point. So you want to go ahead and put them on notice as soon as possible. So the documents you should subpoena and require them to provide you with are as follows. A is going to be civil. So based upon which prosecution concerning case number XYZ, case number may continue after authorized representative has accepted and returned the charging instruments and case for value and posted a bond secured by and through authorized representative's exemption. So it's not going to come at a cost to you. So, and therefore discharge the obligation and ended the controversy. Number 2, certified copy of the assessment in fact on charge on which the charges recase number are based. So yeah, basically essentially what you're asking for is a list of the charges, which would be a true bill version, right? You're going to need the monetary version of that because it is all commercial. So number 3, certified true copy of the order from the Secretary of the Treasury to collect the debt obligation of the defendants, recase XYZ. Certified audit trail of the voucher for monetizing the complaint bond on the case. So essentially what you're asking for here is a forensic, so this is basically like a forensic auditing of the accounting regarding the criminal case here, or if you want to call it criminal, whatever the claim. Let's just call it what it is, the claim. So the detainer authorizing incarceration of defendant and the accompanying physical body of name, recase XYZ. So this would be the order for them to detain or retain your body as as surety for a case based on fake money, and so they're gonna go ahead and try and physically hold you there. What the fuck? You see what I mean? Come on. So their failure to provide any of these items are a tort and grounds for habeas, which is a habeas corpus is to return your body, and it's also, you can also file a habeas for illegal restraint of your property, which is your rights and you do have a right to be free. So they're absolutely infringing on that as well. So as for the evidence you wish to establish on the record, first, while you want judicially noticed as evidence, this should include your court bond. As soon as your documents are filed, obtain at least 2 certified copies from the clerk of the court. Keep one set in a safe place. Take the other set with you into evidence in open court. Once you serve the evidence onto the court, it cannot be denied. You give your documents to the bailiff who serves the judge, and even if the judge throws everything back at you, it does not matter because you already put them on notice. So it doesn't matter what they do with it after. So what you want to do is, what you want to be put into evidence has been served. Right, and so if you do it through a notary as well, then you already have your documentation, and you can go ahead and summons in the notary as your witness as well. And what the fuck are they gonna do then? So the documents for you, to file in the case and serve on the judge in open court should include the following: the judge's oath of office that you received from the Secretary of State or whatever official source provided it to you. Number 2, the court bond that bonds the case, because you're gonna need to see that, because the case has to be bonded. Because these people are operating in the public, and they're risking putting you in a situation where you may get injured monetarily, physically, etc. Right? So that shit has to be bonded, because somebody has to be liable for the injuries that these people are clearly fucking pushing on everybody. It isn't even a question on if. It's fucking all the time. So number 3, so proof that you have accepted the case and all charging instruments for value and returned them for value, because it is all commercial. So see what we got here. So number 4, your judgment and estoppel on the law. First, certificate of non-response that has the notary served, that the notary has served upon the opposing parties. Your judgment and estoppel of the facts, money. Second, notarial certificate of non-response. And these people are going to silently acquiesce because they fucking have to. Okay. So part 4, redemption in court. Or they could just keep playing stupid until the end. You know what I'm saying? But in the end, you're going to win in appellate court and things like that, which they know. But you got to understand, these people are knee deep in the bullshit. They really can't afford to just back the fuck out now at this point. So they're going to go hard. Expect that. Okay. So part 4, redemption in court. The following are points allegedly derived from Roger E. material on the redemption, or 3 questions approaching to function in court. Background. Number 1, the word law comes from Lao. The L was originally a double L, which came from hieroglyphs signifying 2 legs walking. Law, however, is an obstruction because the 2 legs walking around show that law is constantly changing, which it would have to if it's emulating nature, right? Because that's the one thing that's constant in nature is change, okay? So in the United States, for example, Americans get to live under approximately 150,000 new laws every year passed by combined federal, state, and municipal legislatures. Now, keep in mind that these are only codes and statutes which only apply to corporations, which I think essentially everybody's operating in that capacity, whether they realize it or not, when you're using the social and things like that. So you should have a really good understanding of the difference between public and private, and how you can and may end up in contact with these people and get the rug pulled out from under you and shit without even realizing it. So know what you're doing. So in 1984, there were over 200,000 such new laws, which had been informed by attorneys, as well as Westlaw, Lexis, and Nexus, etc. That the law changes so rapidly that in many cases, an attorney must check to see what the law is today before he goes to court. May retort, each time I was informed of that, which if natural law behaves in such an unstable manner. I mean, it's more gradual as far as the way that nature operates, but really keep in mind that essentially it doesn't matter what codes and statutes that they're putting into these books every single year. Ultimately, there's going to be fundamental principles that never change when it comes to commerce, and that's what you should become familiar with, not worried about all this bullshit that they're talking about, because that shit is all just static. So number 2, a court is a place where a contract or agreement is made. A court is a commercial register. One consequence of this is that all courts are courts of record. Indeed, there is nothing with which a judge can deal with except the record. How can a judge act in the absence of paperwork in his possession that inform him of what the case is? And that's the thing. So when you go into court, you're going to realize that the judge cannot move forward without paper. So that helps you understand that court is the paper, okay? So that's how you can hold court through the mail. And when these people silently acquiesced, they already agreed to it, and you already have the judgment because the court is the paperwork, okay? And that's what it is. One of the things that they'll never tell you about. And this is why they're always sending you shit at your house, trying to just sending you offers at your house all the time and shit. If they could just do shit without administratively defaulting you into their bullshit, then they would just fucking do it. But they have to perform the administrative process in order to be good, and then they can go ahead and do whatever the fuck that they want to do after that. So you have to understand the rules to the game. And that's what it is when it comes to commerce. That's one of the rules that never changes. So when you are formulating an agreement, the first thing you need to do is get the name of the second party. This is why in court you first ask the judge if you may have his name. Note, the court is working on an assumption of contract, not an agreement in fact, meaning that they have no agreement from you unless maybe they did it administratively and tricked you into their fucking contract, in which case they do have the fucking jurisdiction because they already secured it by tricking you into it with the administrative process. So they may, but you got to ask for that shit. Ask them where it is, because you need to see that. The redemption dialogue, procedure dialogue. The redemption dialogue makes the court proceeding into a deposition that you are conducting for the purpose of establishing on the record who the claimant is in the case. You are there under threat, duress, and coercion, since guaranteed harmful repercussions are inevitable if you do not appear as commanded. Okay, so you are also there, commanded. You are also there because someone somewhere has made a claim, a color of claim, implying or calling what they allege without foundation, made a claim against you that allegedly justifies enforcing the claim against you by using the legal violence system. By engaging in this deposition, you are actualizing the maxim of law. The burden of proof resides on him who asserts, not him who denies. So you want them to prove the nature and cause of their alleged or implied claim. In other words, you, as the creditor, owner of the court on both sides of the transaction, are requiring them to put up or shut up. Okay, so when you go into court like this, you are exercising your rights under public international law to determine what kind of business these people are trying to do with you. And that's exactly what the fuck it is. Let's just call it what it is. It's business at gunpoint. So these motherfuckers, look, and so you gotta understand like how much money they're fucking making off these people. Why do you think they send these cops out here as fucking pawns to do all their fucking dirty? Because they're making a shitload of money on this shit. That's why they'll send people out there to fucking throw you in the back of a car and kidnap you and fucking bring you to court and all this shit. That's why they fucking do that. Even though they know that shit is wrong, they make a fucking shit ton of money off that. So that's why the fuck they will do that. And count on that. Count on that, you know what I'm saying? So in any interchange between you and the judge, whether it is you requesting that the judge answers something you are asking him or him asking you a question, you must persist until the judge sees that you are not going to give in. This is perhaps especially important if when a judge asks you to state your name or asks you if you are so-and-so, he may ask at least 3 times since the system functions in threes. And there's a lot to that, so I'm not going to get into that now. So the judge needs to know that you are clear and secure about what you are doing and will not cave under the psychological pressure that he is so well trained in applying on those who are before him in court. Likewise, you may have to state your request 3 times until you receive either an answer or a non-answer, which stands as an admission on the record of your position in the matter. So that's going to serve as a verbal administrative process. When you say that to them 3 times, you're giving them an opportunity to cure the second time, and then you're noticing them that they are in default when you ask them the 3rd time, because they do have an obligation and a duty to fucking answer your questions because they work for you. Okay? Remember that. Remember that. So it isn't you that has any obligation. They're the ones who signed that fucking contract and filled out the application. So they can't get stupid about how you want to play the game because you know the fucking rules now. Fuck out of here. So the thing you do is ask the judge for his name, so the record is set concerning the parties entering into an agreement. Therefore, when your name is called, you say, "I am here concerning the matter. May I have your name, please? Request number 1." Okay? So you're trying to get their name on the record. So pay attention to the fact that most judges or justices prefer to give their title, not their name. That's because they operate in a commercial capacity and they're really not trying to be liable privately. But they can be, and they will be. You know what I'm saying? If they don't want to play, if they don't want to play the game correctly. Only if the world was fair, right? So if the judge gives his name request, would you please spell that for me? And you're going to ask him to spell that, right? And you're going to want to know if it's upper, lowercase, and all that too. So if the judge gives you his title, such as Judge Smith, request your offer of communication is accepted for value and your dishonor is returned. Please state your name, not your title. So if the judge states that his name is title/name, you can ask, is that title name, such as Judge Smith, the same title/name that is registered with the Secretary of State? If not, it is fraud and the entire matter is void because the judge is doing business as a name and therefore as a different entity than that which is registered as authorized to do business with or any other derivative of. So 6. Now, if the judge won't give his name, then go ahead with your second request anyway. If someone with whom you are dealing with in court fails to respond or is standing mute, it means you are in control and he is waiving his rights. Request number 2. Do you have a claim against me? He will either stand mute or he will decline to answer, signifying his intent to demur to the matter. When you receive a no answer or a no response or a non-responsive response, go on to request number 3. Do you know anyone who does have a claim against me? Note that you do not say any person or anybody that has a claim. It is anyone who has a claim against me, i.e. a living principal who is alive and breathing in the real world. You are not pleading into a fiction or a legislative venue, which is the major legislative presumption on which the court functions. This presumption stands unless neutralized. So they're going to operate on assumptions and presumptions unless you challenge it, right? You need to ask them, what is making you believe that I have some obligation or contract with you people to perform in any certain fashion? Where is that? Put it in my hand. I need to see that agreement because as far as I'm concerned, there is none. Okay, and I'm here against my will. I don't consent to this bullshit, and I need to see what it is that's making you believe that I have an obligation to entertain you, especially for free, right? So now, if you receive a no answer or non-responsive reply to your request to the judge to inform you whether he knows anyone who has a claim against you, and the prosecutor also says no, then continue by directing the judge. First position as a request statement. I request that the title name please direct the prosecutor to answer whether there is any more charges. Asking this cuts down any more assumed charges. On a good day, the prosecutor will refuse to answer and the judge will dismiss the case on the spot. Right? So these are all possibilities. There's a ton of variables and shit. So at this point, you can direct the judge, second position, as a request that title name, meaning him, please direct the prosecutor to answer whether the assessment for the charges is in his or her possession. Making this request of the judge forecloses the system from acting on the otherwise unneutralized assumption that you are not concerned whether there is a civil assessment to justify the charges. Without an assessment, there can be no charges. And really, I mean, how can they expect you to pay for something if they haven't presented you with the actual bill? They're over here parading as if that shit is some type of criminal charge, when in all reality, it's really civil in nature, which is commercial, and they're beating around the fucking bush. You know what I'm saying? So how can you pay for it if they haven't presented you with the actual bill? What do these charges look like? It's a bunch of words here, and as far as I know, you guys are a fucking corporate business, for-profit business. So why are you showing me these letters and shit? These words and letters. Where's the numbers? Where's the accounting? Where's the true bill? You know what I'm saying? So asking this question puts the prosecutor in trouble, as if he does not immediately drop the charges, he is practicing law without a license, which is a felony, right? Because he's going to be the one there charging you and nobody else is there. The judge ain't saying anything. He has no charges against you. He won't present you with the facts. He won't present you with the actual contract that's making you bound to any of their bullshit. So he's not even there anymore, is he? So now you're dealing with the prosecutor, and who the fuck are they? And they won't present you with the actual true bill here, right? So at this point, you can direct the judge, third position, as a request statement. I request that the title name direct the prosecutor to provide the assessment for the charges along with the certified audit trail of all the transactions held by the mayor of the municipality and the applicable risk management department, including the voucher of all disbursements of the documents and receipts related, right? So at this point, you direct the judge, the fourth position, as a request statement. I request that title name please direct the prosecutor to provide the serial placement number of his or her bar card. No. Many times the prosecutor is not qualified even to be there, which is often the situation in federal court, and the bar card, which is an OMB number, can be used as the number for a surety bond. So look at that. So you can go So you can just go ahead and lean their fucking bar card if you want to. So, I mean, there's so many things that you can do here, and they do not have authority. You need to know that, all right? So, just pay really close mind to the details of the words that you see here, because so many things you can do. Essentially, what this is saying here is that if they don't have a bond or whatever, right, you can go ahead and just get their bar card, which they're gonna have to provide you with, because that's essentially their license to do business, right? That's their you call it, their legal license or whatever you call it. It's bullshit. So essentially, what that's gonna stand as is a surety bond. So that's how you can deal with them directly if you can't access their bonds any other way. Look at that. Also, you want to question the judge to make sure that he's not a member of the bar as well, because they're not qualified to sit and hear a case if they're a fucking member of the bar. That's a conflict of interest. So at this point, you direct the judge, fifth position, as a request statement. I request that title name please stand for the record if you have subject. please state for the record if you have subject matter jurisdiction. No. If there are no further charges, no assessment for the current charges, and no subject matter jurisdiction, the court is in a forfeit position, which they don't want to be in, because you could charge them with whatever the fuck they charge you with, right? Like, personally, privately, if not publicly. You know what I'm saying? So, because the other one's bringing up they're creating this debt out of fucking thin air and not really proving to you that they one, had the legal authority to do that, and two, that you have a legal obligation to entertain that shit. So that shit is straight fraud as far as I'm concerned. So I would make them pay for that shit if they fucking lost, right? I would send them the bill. I would go ahead and I'd go ahead and cancel that on a 1099-C and send that right over to the Treasury Department and let them go ahead and pay for that. So if you elect to utilize the appearance bond matter within this redemption approach, this would be the place to bring the matter up as of this writing request, and appearance bond may be eclipsed by the single page court bond on court pleading paper. Then your sixth position consists of your request for the appearance bond. Making this request in effect puts your name on the account and thereby charges the account, so that when the appearance bond is discharged by appearance, the operators of the account are put into immediate involuntary bankruptcy. If there is no assessment for the charges, more than likely they will not issue an appearance bond, and you can therefore issue a subrogation surety bond against your strawman, right? So 15, should anyone hand you any piece of paper in particular a piece of paper in which they want you to read the assumed charges, scan the front and back of each page and say, I cannot see any charges. Hand the paperwork back to the one who gave it to you, and then request the judge to have a prosecutor read the charges, because you want to have them read that shit into the record, okay? So do not let them waive the reading of the charges. Once more, repeat the request for the assessment for the charges. Persist on this point. Once that point is resolved, state that you are not disputing any of the facts in the matter, and admit to the facts in the charging document. The point is that the system wants you to accept the face appearance of the documents and statements as gospel, so that you self-assess and testify as a witness against yourself. Do not waive the right to require them to provide you with a civil assessment. They never have any valid criminal charges, nor any assessment to support civil charges. All actions today, both civil and criminal, are actually civil, i.e. commercial. Do not let them off the hook and hang yourself. Require that they substantiate the charges. Use your intuition and whether to use next phrase after the gavel has fallen, the discharge. I request that the order of the court be released to me immediately. This is not a question, it is a request, but do not move the court because you do not move the court, because doing so is asking for a benefit. By making the request, you are in essence saying, if there is no first-hand witnesses or claimant present on what are you operating? Give me your marching orders. You are demanding to see the order of the court. So the order of the court being released to you immediately is saying, essentially, you're asking them on what grounds are they moving forward. On what grounds are they moving forward? So 19, when you say or ask, request for these three things, you create a small claims court. A small claims court has different rules and procedures than a commercial, admiralty, equity court. In small claims court, there is no titles of nobility. Attorneys cannot be present. The parties themselves state the claims to small claims court, so we will know who has a claim and who does not. If there are no claims, then there is a default to investigate. This three questions process also constitutes an inquest hearing on a show cause. So you are doing a coroner's inquest or a probate into the matter of any claims against you. In this inquest, only those who have first-hand information concerning the claims may testify. And more often than not, the person that initially made the claim is never even in fucking court. So who's even qualified to speak in there? Nobody should even be speaking in there, to be honest with you. So if you are conducting a public inquest into the matter concerning any claims that may be brought against you and have no claims are brought, the matter is concluded that the public inquest is over and you are out of there. 24. Now, there are some variations that can happen with this. The judge or prosecutor might say the state or province department of XYZ has a claim against you. No, they don't. They may have charges, i.e. what they call charges, but what they actually are presumption of charges, i.e. color of charges, since there is no assessment, but not a claim. So charges are not claims. So, and that's why you got to see who has a claim against you, because that's really what it all comes down to. So some judges get cute saying things like, my name is Judge so-and-so. Well, that's a fiction. That designation does not pertain to any real party and is not a name that can be entered into the commercial register. Judge so-and-so is an unregistered fiction, i.e. doing business under an unauthorized and unregistered name. You can't do that in the public, okay? So at that stage, otherwise you're operating privately and you need to make that known as well. What are you doing sitting in a fucking public building operating privately? Fucking crazy. So at that stage of the game, you should alter your question somewhat. 27. Is there anyone present to press the claim against me in any alleged name other than his own? Right. So everybody, they got the state of, they got the prosecutor. Everybody's operating under they're operating under corporations. So you want to go ahead and get their EINs and all that. You're gonna make sure that these people are even who the fuck that they say they are, because they're probably not, to be honest with you. They're probably not. So at that stage of the game, you should alter your question somewhat. 27. Is there anyone present to press the claim against me in any alleged name other than his own? So if the prosecutor wants to stand up and press that claim, of which there is a minuscule chance, then you demand that he or she be sworn in to testify under the penalty of perjury and as to the damages creating and validating the claim concerning which he is testifying. Now you have your inquest. He is not going to swear in. So you say, there being no claimants who have sworn in under penalty of perjury today with a first-hand damage claim, it would appear that there is no more public business concerning me. I am withdrawing. There is no credible witness and therefore no admissible evidence. No one will swear the responsibility and first-hand knowledge that there is a claim because it does not exist. Even if they have evidence, it is rendered hearsay and presumption for want of any credible witnesses to substantiate the validity of the evidence. Prosecutors and attorneys have no attorney is a credible witness who can testify under the oath on the witness stand that the evidence he places on the record is valid. And he can't do that because he didn't fucking collect it. You know what I'm saying? Come on. So attorney's statement are arguments, not evidence. That is a double fault, since such behavior is both dishonor and presumption. To be evidence, whatever documents are filed would have to be substantiated as valid and verifiable by testimony under oath. No person can do this, i.e. take the witness stand and swear in, because he is not speaking for himself with first-hand knowledge and defined commercial responsibility. He represents by derivative of reinvention what he has been told, the hearsay that he has been told, or thinks would be expedient to say, which would be a fiction. Okay? So don't allow the judge to hoodwink you into allegiance. And number 31, don't follow the orders of the judge, or the judge becomes the head of you and you become the tail. You got to be the one in there asking the questions. And you'd be surprised how much you can get done by just asking questions. Okay? Especially the ones that these people cannot fucking answer. Which is most of them. And if you think about it, who's ever in the courts asking these people questions? Usually you go in there and just get ran down the fucking nonsense bullshit spiel that they give everybody. But you start asking them questions, you're going to throw them off their whole game. You'll probably just leave there. And if all else fails, man, we'll save that for another time. So what is a game of chess? Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.